Mr. Dunson, we're still waiting for the public defender. They were going to join us at 1. It's 1:01. I expect them any moment now.
Okay.
Well, he's not here. Mr. Dunson, there's some things I'd like to ask you about the sequence of how you got here today, but I want to wait for the public defender.
Okay, Your Honor.
Laura, last I knew, the public defender was going to join us at 1. We've yet to see anybody. No, I thought he would be zooming in. I didn't expect to see him live. Maybe it's raining too hard for him to cross the street. Well, that's the hope. Did he call or something? All right. This afternoon was already crammed full. I'm sorry we're wasting this time. Here we go.
Sorry for keeping you waiting.
It's okay. I've been sitting here watching it rain out the window.
This case starts with something you don't see every day, a courtroom literally waiting on a public defender while a defendant sits in limbo. But don't let the slow start fool you. What unfolds is a story of missed court dates, bench warrants, unpaid fines, a suspended license, and a defendant battling serious medical issues while trying to navigate the legal system. The judge is about to lay out a timeline that raises a major question. Were these absences intentional, or was this a case of circumstances spiraling out of control? And just when it seems straightforward, the court uncovers a complicated trail involving incarceration, probation, prior convictions, and repeated failures to comply with court orders. Stay with us, because the judge's reaction to this history and the defendant's request for freedom creates a tense courtroom moment you won't want to miss.
Let's get to it. This is People versus William Lyle Dunson. The file number is 2623220T. Mr. Dunson got a ticket for driving suspended on March 20th, 2026 in Three Rivers. That was at 11 o'clock in the afternoon, 11 o'clock in the evening, 6th and Mechanic Street. And that starts a tale of the defendant not showing up when he was supposed to. And we got.
I was incarcerated.
Hang on a second.
Well,
Hang
for
on.
some of it, you failed to appear a bunch of times. And back in March 10th, you failed to appear. I did a show cause. You failed to appear on March 17th. I finally got you in here on March 24th. I recalled the bench warrant. You pled not guilty. I set up for a pretrial with the prosecutor for April 28th. On April 28th, the courthouse was closed because of a storm. We reset to May 12th and you failed to appear. Then I did another show cause for June 2nd and you didn't show up for that. Then your wife called and said you were coming to the Twin County Probation Center in Three Rivers. So we tried to coordinate with them, and on your last appearance date, you were no longer in the probation center. And I think then we learned that you were in the Cass County Jail. So did you get here from Cass County Jail last night?
Yes, Your Honor. I've been in Cass County Jail since April 10th. And they brought me here last night after I was PR bonded out of Cass County.
All right, so I had excused an earlier bench warrant because we got you in here and then you got incarcerated and then we didn't know it. And I thought you were at Twin County and you weren't. And then I put a hold on you so we could get you here today. So let's go back to square one. You're charged with driving with a suspended license, first offense. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. You have a previous driving suspended conviction in this court from 2021. You failed to pay the $125 fine. That's still due and owing. Then you got another driving suspended in 2025, which was reduced to allowing another to violate the motor vehicle code. And that you owed $325 and you never paid anything.
I'm currently in the process of paying payments on all of my court fines right now.
All right.
I got an agreement with the courts to pay $50 a month because of my my issues with my lung cancer and everything.
Yes, you're also struggling with some medical issues. I don't think anything's been paid on any of that since last October. At any rate, this charge is a driving suspended charge. You pled not guilty. I set it for a pretrial. We never were able to accomplish it because you weren't here. The city attorney is here, Mr. George, by happenstance. And I don't think they wish to make any plea offer in this case because you already have a driving suspended. You had another driving suspended that was reduced and you didn't pay the fine. So it's charged as a first offense. I guess it could be charged as a second offense if they wanted to do it under state statute. So you've got about 5 days of credit. If I go from April 10th, well, I don't know at what point I put the hold on you. I put the hold on you on June 2nd. So you would get credit for 15 additional days. You have 20 days of jail credit. I don't envision giving you any additional jail time if you plead to this. I'm going to give you the minimum fine and put it on the payment plan that you're theoretically on. But you don't have to plead guilty to the charge if you don't wish to. You can set it for further proceedings. If you do plead guilty to it, it's going to go on your driving record. It's going to further your suspension and it's going to carry 2 points. What do you wish to do here?
Will I get out of jail today either way?
Well, not either way. I'm gonna give you 20 days credit, 20 days. If you plead not guilty, I'm gonna get an attorney appointed to represent you, and set it for further hearing.
Okay. I would like to take that route if I can get a PR bond today.
I'm not inclined to give you a PR bond. You missed multiple court appearances before you went to jail in Cass County. This is the third time in 4 years you've been charged with driving suspended. The last time they gave you a break and reduced it to allowing another to violate the motor vehicle code. And you didn't pay 1 cent of the fine. So I would be inclined to give you a bond of $519, which is the amount of your unpaid fines and costs. So I don't want.
Let's pause here because this is a critical legal moment. Notice what the judge is doing. On one hand, he's making it very clear that Mr. Dunson's history isn't helping him. Multiple failures to appear, unpaid court obligations, and repeated driving suspended cases all work against him when it comes to bond decisions. On the other hand, the judge is equally careful not to pressure the defendant into pleading guilty simply to get out of jail. That's an important distinction in court. A guilty plea must be voluntary, and judges have to avoid creating the appearance that someone is pleading just to secure immediate release. At the same time, the judge is weighing accountability against compassion, especially considering the defendant's incarceration history and ongoing medical treatment. What do you think? Should a defendant with this record receive another chance? Or should prior failures carry more weight when the court considers release and sentencing decisions?
To bully you into pleading guilty. So if you wish to have a lawyer appointed, I set it for pretrial for next Friday, the 26th of June. My intention was to give you 20 days credit, 20 days, let you out of jail and see if you would pay on your fines. But
I would like to take that route, Your Honor.
all right, well, let me go through a couple things. Do you understand that if you do plead to that charge, you'll be giving up your right to have a trial in front of a judge or jury? Do you understand?
I understand, Your Honor.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Stickley is here simply as an advisory capacity at this point, but if you wanted a lawyer, I'd appoint one for you. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf, because you have a right to testify, but you also have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to have the witnesses for or against you subpoenaed to come to court, and you have the right to be presumed innocent. Now, let's talk about some other things. Do you feel like I threatened you or coerced you to get you to enter this plea by expressing my unwillingness to give you a PR bond if this matter had to be continued?
No, Your Honor.
Is it your choice to enter a plea to this charge of driving suspended?
Yes, Your Honor.
Anybody promise you anything other than what I said about the 20 days jail credit?
No, Your Honor.
Where were you going back last February at 11 o'clock at night?
I was on my way back to drop my daughter off at her house. She went with me to my lung cancer injection, so that way she knew I was okay. I get a radioactive injection on the 26th of every month.
Yes, and your license was suspended at that time?
Yes.
I'm going to give you the very 5 days that you got prior to this when you didn't show up. I kept doing show causes because I know that you had some medical problems. I tried calling your phone number twice, and you kept paying me back by not showing up. I don't know if you showed up on April 28th, the day the power was out.
Yeah, I was incarcerated, Your Honor.
Oh yeah, by April 28th, you were incarcerated.
Yeah, I've been incarcerated since April 9th.
Well, you missed April 24th, excuse me, March 10th, March 27th, March 24th, you showed up. I set it for March 30th. Anyway, I'm gonna give you 20 days jail credit, 20 days. I'm gonna do the minimum allowable fine of $125, part of your payment plan. I don't believe you've been making any payments. You may have a circuit court application. You owe them money, but the district court, I haven't seen that you've made any payments since 2025.
I was under the impression that it was all in one thing. I was only paying the one. I can pay both.
No, you're paying circuit court. You're not paying anything on your district court fines. And what
Yeah,
really
I didn't
hurt me is you got a break the last time. They reduced it to allowing another to violate the motor vehicle code, and you didn't pay anything.
Yeah, I was
Anyway, you're
completely
gonna get
unaware
out
that it
of,
was.
if there's nothing else holding you, when you get out of jail, I want you to stop up here at the courthouse
Absolutely.
and set up a payment plan.
Absolutely.
All right, you're good to go. You've got somebody that'll pick you up?
Yes, I do.
All right, it's pouring rain out there. All right, Mr. Dunson, stop driving. I know you got to get to appointments, but your license is suspended several different ways.
I absolutely don't intend on driving there. I got.
All right, you're good to go, sir. Thank you.
Thank you.
This hearing ultimately ended with the defendant pleading guilty to driving while suspended, and the judge imposed what was effectively the minimum financial penalty while granting 20 days of jail credit. The court also chose not to impose additional jail time, allowing Mr. Dunson to be released if no other holds existed. Throughout the hearing, the judge repeatedly balanced two competing realities: the defendant's serious medical challenges and incarceration history versus a documented pattern of missed court appearances, unpaid fines, and prior driving-related violations. The broader takeaway from this case is that courts often consider much more than the charge itself. They examine compliance history, credibility, prior opportunities for leniency, and whether a defendant has followed through on previous court orders. In the end, accountability and discretion met somewhere in the middle, producing a resolution that emphasized both consequences and a final opportunity to get back into compliance with the law. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.